Hello, welcome back. This is Subathra Mylsamy, partner at AK Mylsamy and Associates. So today we are going to get into a very technical topic and also a very corporate topic, which is nothing but on insolvency and bankruptcy laws. So I'm going to talk to you today about the pre-packaged insolvency resolution process for the insolvency of MSMEs. So in order to provide a very efficient and alternative insolvency resolution process under the code, the pre-packaged insolvency resolution process for the MSMEs was brought in. So the reason why it has been brought in is to ensure a quicker and cost-effective and value maximizing outcome for all the stakeholders in a manner in which it becomes very least disruptive to the continuity of their business and also which will preserve their jobs. The pre-packaged insolvency resolution process is built on trust, and it honors the honest MSME owners by enabling resolution when the company remains with them. Now, this pre-packaged insolvency resolution process is actually regulated under the Chapter 3A of Part 2 of the IBC. Now, let us see the eligibility process for this insolvency process which I've been talking about. Here it is the corporate debtor has to be registered as an MSME under the MSME Act and will be eligible under these following categories. One is if they have committed a default of at least of rupees 10 lakhs, and if they have not undergone this PPIRP during the 3 years preceding the initiation date and has not completed a CIRP during these 3 years preceding the initiation date, and also if they are not undergoing a CIRP. And the last eligibility point is it is not required to be liquidated by an order. The most often asked question is, what is the difference between the CIRP process and the PPIRP process? Now, CIRP is nothing but the corporate insolvency resolution process. Under this, it is applicable to any corporate debtor where the minimum default is for rupees 1 crore. Now, under the pre-packaged insolvency resolution process, it is applicable to a corporate debtor who falls under the category of an MSME where the minimum default is 10 lakhs. Another important difference which we see under the CIRP process and the PPIRP processes. Under the CIRP, if you notice, there is no preliminary work required before the filing which you have to do in the NCLT, either by the financial creditor or by the operational creditor. Here, the corporate debtor has to only pass a special resolution. But under the PPIRP process, preliminary work is required before filing application to the NCLT, which is the special resolution. Under that, if you see, an approval of at least 66% from the financial creditors is required. You need to also furnish the name of the resolution professional, plus the base resolution plan by the corporate debtor has to be furnished. And also you need to give the registration details of the MSME. And finally, the report by the resolution professional. So under the CIRP process, who can initiate this if you look into? It is the persons who is a financial creditor under the Section 7 and also an operational creditor who's under Section 8 and the corporate debtor itself or its promoters who fall under Section 10 of the IBC Act. Under the pre-packaged insolvency resolution process, only the corporate applicant, normally it is the corporate debtor itself or it's the promoters or directors, can initiate the PPIRP process. Next is the time limit under this process. So under the CIRP, the time limit for completion of this entire process is actually to 180 days, and the maximum it can be taken to is about 330 days. Now, under the PPIRP process, the time limit for completion of this process is within 120 days. Now, there is also a provision of appointment of interim resolution professional, which is called as the IRP under the CIRP process. Whereas under the PPIRP process, there is a direct appointment of the RP. So under the CIRP, the management of the corporate debtor, it vests with the IRP, which is the interim resolution professional, on the insolvency commencement date. Now under the PPIRP, the management of the corporate debtor continues with the corporate debtor unless a fraud is involved. In this case, the COC can resolve to vest the management with the resolution professional. The next notable point is the constitution of the committee of the creditors has to be within 30 days under the CIRP process. And the constitution of committee of the creditors has to be within 7 days under the PPIRP process. So under the CIRP process, the resolution professional is appointed in the first meeting of the committee of creditors. Now under the PPIRP process, the resolution professional is already appointed well before making an application to the adjudicating authority, and which is to be only confirmed by the adjudicating authority here. Now the preparation of information or the memorandum is by the resolution professional under the CIRP process. Here the preparation of information or the memorandum is by the corporate debtor and the finalization is by the RP under the PPIRP process. So under the CIRP process, there is no provision for the base resolution plan by the corporate debtor, whereas under the PPIRP process, the corporate debtor may improve the base resolution plan and also the committee of creditors may approve the same. And it also will be done with some kind of improvements if it does not impair the operational creditors. Now next is under the CIRP process is the evaluation matrix, which has been approved by the committee of creditors for the consideration of the resolution plans and its approval. Under the PPIRP process, the scoring as well as the improvement of the resolution plan, it will be done as per regulation 42. So to sum it up and to conclude, the IBC code was brought in with the objective, which is to consolidate and to make amendments to the laws, which is relating to the reorganization and the insolvency resolutions of the corporate persons, plus partnership firms and individuals in a very time-bound manner for maximization of value of their assets of such persons, as well as to promote entrepreneurship with the availability of the credit as well as the balance the interest of all the stakeholders. And there is also a lot of changes which is happening currently under the IBC code, and I think we have a long way to ensure and enable it to become very effective. I hope this video was informative. Thank you so much for watching. See you next time. Bye-bye.